accountants and lawyers have both been found in scandals of misappropriation and dishonesty, like when accountants, enjoy uh, the contents of someone's trust accounts, but the lawyers are intimately detested and their profession is tarnished, according to TimDare's opinion in the Council of Frogs. So he says that even while accountants also have cases where they are corrupted, their profession, they are not personally branded as thieves and liars, whereas lawyers, on the other hand, are unfairly branded as dishonest. Okay, so he continues to say the difference between the lawyer jokes and accountant jokes is informative. Jokes about accountants do not tread upon dishonesty, even though there are plenty of spectacular cases of misappropriation by accountants, because there is no perception that the accountant's role is of its very nature dishonest. The dishonest punchline is not a sufficiently plausible conclusion to the narrative of the joke, because dishonest accountants are taken to act outside their professional roles, whereas individual lawyers could misappropriate clients' funds and do all this dishonest stuff, but they will be taken to be the profession itself is dishonest. Okay, they will not go down by themselves. They go down by taking a punch to the profession. Okay, so he says the difficulty for lawyers is that there is a widespread perception that even when lawyers are acting squarely within their roles, even when they act as good lawyers, they display the vices of dishonesty and deviousness. So now here comes the difference. There are certain principles in the law profession that make even good lawyers who follow these principles to be bad people and morally unacceptable people in the society. Like, for example, when a lawyer is bound to defend a criminal who has maybe sexually assaulted people, like in the case of Larry Nassar, okay, you can imagine the lawyer who was representing him. According to the cab rank rule, you have to represent even the worst types, yeah, just because they are they are, you cannot discriminate on how good or how bad, evil a person is. They are entitled to be represented by an advocate. Okay, so this is what he's saying. They display the vices of dishonesty and deviousness even when they are acting as the best kind of lawyers. The widespread suspicion of lawyers' ethics, and hence the punchlines to lawyer jokes, flows less from rare cases of misappropriation than from common perceptions of the day-to-day business of law. So it's not about the scandalous cases where lawyers have done away with clients' money or this and that. It's about the profession itself. Okay, Now, at the heart of the difficulty is a conception of the lawyer's role, often called the standard conception, according to which lawyers owe special duties to their clients, which render them permissible or even mandatory acts that would otherwise count as morally impermissible. I said this, okay? I said this. You have to defend your clients, okay, and protect their interests. That's a lawyer's role. You have to represent whoever is entitled to representation by you, no matter how criminal, how devious the charges are. So it's all about the lawyer's role that places them and the entire profession as morally unacceptable. So we give a case of Zabella versus Pakel. Now, Zabella versus Pakel has become a classic illustration. The case raises the issue of a lawyer's use of legally available defenses to allow a client to avoid a moral obligation. Joseph Zabella worked for John Pakel. Zabella was better off than his employer, interestingly, and from time to time loaned him money. Eventually, Pakel owed Zabella $5,000. That's a lot of money. The two drafted and signed a simple contract, but Pakel declared bankruptcy before the debt was repaid. Sometime later, Zabella sued, claiming that subsequent to the bankruptcy, Pakel had made a new promise to repay the debt. The new promise would have blocked the bankruptcy defense, but because it was not in writing, Pakel was able to plead a statute of limitations to prevent legal enforcement. The defense was successful, though the court was quite explicit that the statute did not extinguish Pakel's moral obligation to pay Zabella. The immorality of Pakel's reliance upon the statute was made all the more striking, since by the time of the suit, Pakel had become the well-paid chief executive officer of the Chicago Savings and Loan Association and could have repaid the money without hardship. Though they felt obliged to allow the defense, the court made clear they thought Pakel was a scoundrel who, being in a position of some affluence, should feel obliged to pay an honest debt to his old friend, employee, and countryman. So you see, the lawyer was representing Zabella was actually, no, the lawyer who was representing Pakel, who is the defendant in this case, had to represent his client and follow his client's instructions, you understand? Even when clearly Pakel was avoiding a moral obligation to pay back the debt that has been owed to him by his friend and employee Zabella. So surely the court is right about Pakel, somebody who relies upon a technical rule of law to avoid paying an honest debt to an old friend who helped the debtor when the debtor was in need, when the old friend is now in need, and when payment would not significantly reduce the debtor's own welfare, acts immorally. You see what I'm saying? So what though of Pakel's lawyer? Normally one who knowingly helps another obtain an immoral and acts immorally. So now the lawyer is kind of abating, and helping or providing the means by which Pakel could get away with not paying back the debt owed to him. You understand? But the standard conception gives lawyers a different and straightforward answer. According to the standard conception, not only did Pakel's lawyer do no wrong in helping Pakel secure his rights under the statute of limitations, he had a positive professional duty to do so. You see, this is a lawyer's role. You have to protect the interests of your client. and you have to use the knowledge and expertise you have in that area in which your client is demanding help, and identify, ways to which you can, help acquire your clients, uh, acquire an outcome that will be beneficial to your client. You understand? So, being a good lawyer required conduct which would have been condemned as morally improper had it been performed by a lay person. Yeah? It is the conception of the lawyer's role which has this result that prompted Macaulay to ask how it be right that a man should, with a wig on his head and a band around his neck, do for a guinea what without these appendages he would think it wicked and infamous to do for an empire. You see? So it is the standard conception of the lawyer's role that places him in a position to do stuff that would otherwise be morally unacceptable even to himself. Okay? So, and it is this conception that creates in the minds of many an enduring and intimate connection between the practice of law and the vices of deviousness and dishonesty. Alright? This analysis may seem to have an obvious implication if it is this conception of the lawyer's role that explains the common association of lawyers with the vices of dishonesty and deviousness. Shouldn't we abandon the conception? Now TimDare is saying, if this standard conception of the lawyer's role is what is causing the profession to be morally unacceptable and to be frowned upon by the community or the society in which we live in, shouldn't we let go of this standard conception maybe and assume another conception that will balance, out this immorality, and maybe replace it with a morally acceptable role that lawyers could play? Indeed, we will see that the difficulty may be rather more onerous than has so far been suggested. The standard conception has been subject to a diverse and sustained critique. According to this critique set out in more detail in Chapter 2, lawyers acting under the standard conception are alienated from ordinary morality. Okay? So lawyers who are acting under the standard conception of their role are alienated from ordinary morality. Now, this is an interesting way to look at this. Now, TimDare is saying that lawyers should not be treated the same way as laymen as far as their profession or their professional role to their clients is concerned, because once they put on that robe and that wig, they shouldn't be considered as people on which ordinary moral rules could apply. Okay, I don't know if you get me, but this is really interesting. So lawyers should not be subject to the ordinary morality that is applicable to everyone else in the society. So they are invited to deny responsibility for the things they do, and thus to deny their status as moral agents capable of choosing to do otherwise. They are rendered morally insensitive in ways which impair their ability to both to live a satisfactory life outside of their professional roles and to perform their professional roles adequately, and are likely to find their work deeply unsatisfying because of the striking discord between the apparently obvious and public concern of law and lawyers with justice and morality, and the reality of practice and a conception which separates the moral obligations of the lawyer from those of the rest. So TimDare is arguing that this kind of separation this kind of segregation of the lawyer's professional role from their personal life is actually having a negative impact on these people, is actually having is affecting them. They cannot fit in the society. Their family and neighbors and friends would frown down upon them, and they will be affected obviously psychologically, and their professional life will also be ultimately affected. Again then, isn't the implication of all of this that we should abandon the standard conception? Certainly, this is an implication drawn often enough to make the standard conception an ironic epithet. If numbers count, the standard view is now that the conception cannot be right. It has passed from orthodoxy to fair game, replaced by a new orthodoxy that it must be abandoned, to be replaced by a conception that better allows the lawyer to bring his full moral sensibilities to play in his professional role. So there's an evolution here. Okay, but I do not believe that the standard conception should be abandoned. So TimDare is for the standard conception. Okay, I shall argue that a slightly modified version of it is essentially the right way of conceiving of the ethical obligations of lawyers. So he is proposing that this standard conception, which alienates lawyers from the society, should not be abandoned but should be modified. Okay, should be upgraded or balanced with ethical with some ethical additions and spice there, to make it to make it ethical. I'm basically repeating myself. Now, those concerned with the ethics of the profession, whether these assessors are themselves lawyers or not, should regard lawyers as subject to distinct obligations and permissions when acting in their professional capacities. You see, so he's still opting for the segregation of lawyers, of lawyer roles from their personal ordinary life. So when they put on that robe and act from their capacity, professional capacity. And yet the long line of criticism of the conception cannot be ignored. I hope to show why we should hold on to the standard conception and how we can do so while acknowledging the most significant aspects of the critique. Yeah? Up to there we are good. Now, let's move on. The overall strategy is straightforward. TimDare is now proposing a modification of the standard conception of the lawyer's role, and only choosing to address some significant part of the critique, okay, on the lawyer's professional role by the society and by whoever it is who sits down to judge who is wrong and who is right. And he's not addressing, like, he doesn't view the whole critique as important or significant and worthy of addressing, but only considers some significant parts. So let's see, the overall strategy is straightforward. I argue that lawyers have moral grounds for regarding themselves as having duties to their clients, which may allow or require them to act in ways which would be immoral were they acting outside of their professional roles. The fact that lawyers act within professional roles, I claim, makes a moral difference. Okay, if the moral justifications of the lawyer's role can be defended and are sufficiently weighty, many of the criticisms of the standard conception fall away. Okay? Most generally, if there are moral reasons for taking the standard conception seriously, then we should not too readily accept the claim that the conception alienates lawyers from morality. This is to say that we should not overdraw the conception's break between personal or ordinary morality on the one hand and professional morality on the other. If the moral defense of the standard conception is successful, an adequate personal or ordinary morality will entail a proper respect for the moral demands and permissions of professional roles. The moral argument also suggests a solution to the crisis of morale. It suggests that contemporary liberal communities rely to a considerable extent upon the practice of law as conceived by the standard conception. Law so practice allows people who are committed to a range of diverse but reasonable views about how we should live to form stable and just communities. The lawyer's role, so conceived, is one in which lawyers should take a good deal of satisfaction. The crisis of morale that troubles so many commentators is attributable, I will suggest, to a failure to appreciate the moral justification for the role rather than to any general licensing of immoral professional conduct. Indeed, once the moral arguments for the standard conception are made explicit, those arguments themselves suggest limits to the things lawyers may justifiably do within their professional roles. So what TimDare is saying is that what if the professional roles of lawyers or the standard conception can be justified? What if there are moral arguments to explain, or in this case to redeem or justify or excuse this professional role or the standard conception of a lawyer's role? And the same justification, the same argument that is supporting it could limit the amount of limit the how far the lawyers can go. Okay, the same arguments justifying the standard conception will be the same to limit and set rules and principles and boundaries which lawyers cannot cross, and if they do cross, then obviously they are now a criminal element, like they are subject to maybe disciplinary committee or something. Yeah, the moral implications of the standard conception are often mischaracterized. Commentators suggest that the conception requires lawyers to secure any advantage the law can be made to give. Okay, but I shall argue that the standard conception, understood in light of its proper moral justification, requires no such thing. It justifies a more limited and moderate sphere of professional conduct. Clearly, more needs to be said on all of these issues, and aspects of the critique remain unaddressed. This will do, however, to indicate the direction of the argument advanced in this book. You understand up to this point? So, TimDare is simply saying that an argument to justify the role the lawyers play exists, and that argument will also propose a more limited and moderate sphere of professional conduct in which lawyers can, which will set how far lawyers can go and where they need to stop. Okay, so let's continue. The standard conception of the lawyer's role. Subheading. I begin by setting out the principles that comprise the standard conception of the lawyer's role. According to that conception, the relationship between the lawyer and the client is mediated by three principles. So we have them here. The principle number one is the principle of partisanship. Excuse me as I drink some water. So, the first principle is the principle of partisanship. First, this principle specifies that the lawyer's sole allegiance is to the client. Okay? That's principle number one. Within, but all the way up to the limits of the law, the lawyer is committed to the aggressive and single-minded pursuit of the client's objectives. This is what I said earlier on, that a lawyer's role and his goal and aim is to satisfy the client's desires. Okay, this is what the principle of partisanship entails. Lord Brougham's defense of Queen Caroline is often regarded as the classic statement of the principle. Caroline and the Prince of Wales entered into an arranged marriage in 1795. Okay? The prince's main motivation was not romance, but a pressing need for financial support from a parliament insisting he abandon a spendthrift bachelorhood. The couple met only shortly before the wedding and seemed to have instantly fallen into a deep, mutual and enduring loathing. I was expecting to see love or something. So it's loathing. They hated each other. They separated almost immediately. Caroline did not retire into a demure solitude. Rather, she led a merry life in London before returning to Europe in 1814, where she toured and eventually settled with an Italian cavalry officer who was plainly more than a mere traveling companion. When George came to the throne, in 1820, Caroline was offered a gratuity to renounce the title of Queen. She refused. At George's insistence, a reluctant government introduced what was in effect a divorce bill to the House of Lords. Lord Brougham defended Caroline against what were essentially charges of adultery. He had an ace up his sleeve. He knew that in 1785, George had secretly married Maria Fitzherbert, a Catholic widow. The marriage was almost certainly invalid. The Act of Succession prohibited heirs to the throne marrying Catholics, but Brougham believed that he could bring down the unpopular king by publicizing George's marriage to Mrs. Fitzherbert, and insisted that he was duty-bound to use that power if he could advance his client's cause by doing so. An advocate in the discharge of his duty, he said, now let's hear Lord Brougham, who represented Queen Caroline. Now, an advocate in the discharge of his duty knows but one person in all the world, and that person is his client. To save that client by all means and expedients and at all hazards and costs to other persons, and among them to himself, is his first and only duty. And in performing this duty, he must not regard the alarm, the torments, the distraction which he may bring others. Separating the duty of a patriot from that of an advocate, he must go on reckless of consequences, though it should be his unhappy fate to involve his country in confusion. In the face of Brougham's defense, the bill sneaked through the House by a mere 9 votes. Given the level of public and political opposition, the government quietly dropped the bill. Now, the principle of partisanship, often referred to simply as the duty of zeal, appears in one form or another in the professional codes of the lawyers of many jurisdictions. So, even in my country, lawyers have a duty to protect the interests of their client and to use their knowledge and expertise to represent them and work hard to make sure the outcome favors their client. Do their best, So, TimDare gives an example of the American Bar Association, states that a lawyer should represent a client zealously within the bounds of the law. The same to my country. An earlier version from a less succinct age, proclaimed that the lawyer owes entire devotion to the interests of the client, warm zeal in the maintenance and defense of his rights, and the exertion of his utmost learning and ability. Like I say, the International Code of Ethics specifies that a lawyer shall without fear defend the interests of his client and without regard to any unpleasant consequences to himself or to any other person. You see this here is interesting. So we have the International Code of Ethics. We also have the American Bar Association, both proclaiming this principle of partisanship, okay? Now, continuing, the New Zealand rules, we have the New Zealand rules, provide that lawyers shall, subject again to a duty to the court, fearlessly uphold the client's interest without regard for personal interests or concerns. Alright? So, I think what TimDare is trying to argue is that the professional role or that space where lawyers stand, to defend or represent their clients should be enough. The amount of demand that is expected of a lawyer when representing their client in this principle of partisanship should be enough to excuse lawyers from the hate and the ridicule and all the lawyer jokes and all the blame and judgment these people receive, okay? Because the role demands so much of them in their capacity as lawyers, okay? Now, moving on. The principle is standardly portrayed as flowing directly from the adversarial system, which is said to structure legal proceedings as contests, jousts even, between the parties. In our country also, we have the adversarial system, okay? Lawyer against lawyer, client against the other client. So, a lawyer acts as their client's champion. They are to do all they possibly can within the rules of the game to see that their client's interests prevail. This is repetition, I already said this. Judges act as impartial umpires, seeing to it that the parties follow specified procedural rules like rules of evidence, tendering evidence and stuff, and rules of procedure, and deciding which side makes the best case in light of the relevant substantive and procedural law, like I said. The very presence of such umpires may provoke especially zealous advocacy. In an In an umpired contest, it is the umpire's job to spot fouls, to interpret and apply rules, and to decide who has won. Players may abrogate responsibility for ensuring compliance with the rules to the umpire, pursuing any advantage the umpire will allow. The game can continue with little self-restraint from the players, deviations being limited by the umpire. In an informal or non-umpired game, by contrast, if each side insists on doing whatever they can get away with, the game will stall. Teams and coaches must, therefore, exercise more restraint in the pickup game than in the refereed contest. Okay? We will examine the justification of the principle of partisanship in greater detail below. Before moving on, however, I wish to introduce two alternative ways of understanding the principle. The difference between the two turns upon the ends towards which the lawyer's zeal must be directed. According to one, the principle calls upon lawyers to exercise what I shall call mere zeal. Merely zealous lawyers are concerned solely with their clients' legal rights. They pursue those rights without fear and without regard to any unpleasant consequences to themselves or to any other person. According to an alternative understanding, the principle requires lawyers to exercise what we can call hyperzeal. Hyperzealous lawyers are concerned not merely to secure their clients' legal rights, but instead to pursue any advantage obtainable for the clients through the law. Indeed, they are not really attempting to defend legal rights at all, they are attempting to win. Now you understand the difference. The mere zeal lawyers and the hyperzeal lawyers. Now in the case of Isabella versus Pakel, I would assume the lawyer representing Pakel is the hyperzeal kind of lawyer, because all he wanted was to obtain the advantage of the statute of limitations to make his client win or even escape the moral obligation to his friend to pay him back. Okay? Indeed, they are not really attempting to defend legal rights at all, they are attempting to win. That's, I say, the difference between the merely and the hyperzealous lawyer turns upon the distinction between a person's legal rights and all that the law can be made to give them. David Luban writes, my legal rights are everything. I am in fact legally entitled to not everything the law can be made to give. For obviously a good lawyer may be able to get me things to which I'm not entitled. Every lawyer knows tricks of the trade that can be used to do opponents out of their legal deserts. Using delaying tactics, for example, to make it too costly for an opponent without much money to prosecute a lengthy suit, even though the law is on her side. Or filing a nuisance claim carefully calculated to be cheaper to settle than defend. Alright, so we can see the example of a hyperzealous lawyer as according to David Luban's statement. Now, put in terms of the distinction between mere and hyperzealous, Luban takes the standard conception to call upon lawyers to secure the goals of mere zeal by adopting the tactics of hyperzeal. The no-holds-barred zealous advocate, he writes, tries to get everything the law can give and thereby does a better job of defending the client's legal right than a less committed lawyer would do. He concludes then that the standard conception requires lawyers to act hyperzealously and hence improperly. But I will argue that the distinction between mere and hyperzeal can be maintained, and that with which the distinction in place, the demands of the standard conception are quite proper. Now, the next principle, remember we are still in the principle of the standard conception of a lawyer's role, we have been told in detail what the first principle of partisanship is. That is devotion to your client's desires, making sure you apply your knowledge and expertise to help your clients get a favorable outcome. And we've seen the two types of advocates, the merely zealous and the hyper zealous. And we have seen that the merely zealous will uh, ensure to use the law to the benefit of his client, whereas the hyperzealous will go so far as to use delaying tactics and tricks to get what they want. So the principle of neutrality, neutrality. The second principle of the standard conception states that the lawyer must remain professionally neutral with respect to the moral rights of the client or the client's objective. Okay, this makes sense. Now, the principle states the lawyer must not allow their own view of the moral status of the client's objectives or character to affect the diligence or zealousness with which they pursue the client's lawful objectives. The lawyers must not allow their own view of the moral status of the client's objectives or character to affect the diligence or zealousness with which they pursue the client's lawful objectives. You guessed it right. This is that principle which says do not discriminate a client. As long as the case falls in expertise at the usual fees that you normally charge, your field of knowledge, you are obliged by the cab rank rule to represent a client who comes to you for representation, and in doing so, the principle of neutrality demands that you should not, by any means, charge your law. You should not, by any means, work less hard, in your efforts to represent your clients just because they hold immoral objectives or just because they are bad people. The rationale for the second principle is clear enough. It guards against the possibility that someone might be denied rights allocated by a legal system because its lawyers find those rights or their allocation to that person morally objectionable. In the extreme case, if we assume that legal representation is at least sometimes necessary to secure legal rights, the lawyer or community of lawyers could render the person's claim to their lawful rights worthless by refusing to represent them at all, or by making a less than zealous effort on their behalf. Richard Wasserstrom makes the point in a classic article: if lawyers were to substitute their own private views of what ought to be legally permissible and impermissible for those of the legislature, this would constitute a surreptitious and dangerous shift from a democracy to an oligarchy of lawyers. I don't know what he said, but I just think what he was trying to say is that lawyers should not judge the people they're representing. They should work as hard to represent a bad client as they would to represent a good client. By good and bad, I mean morally. They shouldn't just want to represent clients uh, who have rights owed to them, and they should also represent that client who took rights from who is the perpetrator, It's likely to have been the one who killed, in that murder case, the one who raped, the one who assaulted, the one who stole, the one who, like Pagel, uh, broke a friendship and trust and became like a constructive thief. I'm not gonna read too much into this because I'm sure that it's just going to explain more in detail. So basically, this principle of neutrality bars lawyers from sitting down and thinking whether to take on a client or not. Okay? So, like I said, this principle of neutrality is in the cab rank rule, which requires a lawyer to take on any case within their area of competence as though they were the next cab or taxi at the rank, without choosing or picking their clients. Provided only that the lawyer has time to take the case, has sufficient experience and expertise, a reasonable fare or fee is agreed, and that the lawyer has no prior inconsistent interest or conflict of interest. Okay? So the classic illustration of the rule allows us a serendipitous economy of villains, albeit at the cost of remaining in the 18th century. So, and until here we understand. The third principle is the principle of non-accountability. Now, this principle is the final principle, and this one is most clearly expressing the core idea of the standard conception. The idea that the role obligations of lawyers are distinct from those of ordinary morality. So this principle seeks to make lawyers, to excuse them when they are acting in capacity or out of their professional, when they are acting in the capacity of their professional role as lawyers, whatever it is they do, of course within the limits of the law, subject to their duty to the court, obviously, they are excused or should be excused from any moral liability. The idea that the role are distinct from those of ordinary morality. Now they shouldn't be judged. That's what this is saying, this principle. When a lawyer is acting in their capacity to defend their client's interests, they shouldn't be judged or subjected to the same ordinary rules or morals that a common men are subjected to. Okay? or rate themselves at. So, like I said, repetition. The principle of neutrality purports to exempt lawyers from the normal moral practice of judging someone to have acted immorally, okay, if they have knowingly and deliberately helped another to act immorally. So lawyers are excused from being judged by this principle, okay. According to the principle, a lawyer is not to be judged by the moral status of their client's project, even though without the lawyer's assistance, the client would not have been able to pursue those projects. Since the lawyer lends his exertions to all, himself to none, we cannot identify the moral character of the lawyer by reference to the causes they have advocated. So understood, the principle follows naturally from the first two principles, though it is importantly different from them. It follows from them in acknowledging that given the standard conception, we cannot properly assume that lawyers identify or sympathize with their clients' goals. The lawyer might have strong moral objections to a client's project, but be forbidden from relying upon those objections by the principle of neutrality and obliged to assist the client zealously by the principle of partisanship. Now, I think up to this point we have uh, understood the standard conception of the lawyer's role that is explained by these three principles: one of partisanship, one of neutrality, and one of non accountability. The principle of non accountability differs from the first two principles. However, in focusing not upon how lawyers should conduct themselves in professional practice, but upon the grounds on which lawyers might legitimately be judged from a moral point of view. Yeah. So TimDare is basically saying that lawyers may use this principle of non-accountability as a defense to take on unpopular cases with clients who hold like immoral views, like the Nazis, for example. They may plead the rule in response to the mistaken assumption that they would not have taken on the case if they did not endorse the goals of the client. Hence, the Cabranc rule contributes to the effectiveness of the principle of non accountability. Okay? So he gives the statement of Lord Reid, who said that for any person, who said that if a counsel is bound to act for any person, however unpopular or offensive his opinions may be, okay, no reasonable man could think the less of any counsel because of his association with such a client. But if counsel could pick and choose, his reputation might suffer if he chose to act for such a client, and the client might have great difficulty in obtaining proper legal assistance. So the lawyers in the standard conception, according to the first two principles of neutrality and partisanship, do not have the freedom or the privilege to choose and pick their clients. That is why they should not be judged for those times when one of those clients turns up to hold evil opinions, Okay, so that's about the summary of the standard conception as explained in the three principles. I will see you next time. We continue this. Bye bye. Ciao, ciao.